Hello and welcome. This is David Lentz. Please be advised that this video really only discusses Virginia state court cases. If you have a federal case, please contact us and tell us about your case. Thanks.
Hello folks, this is David Lentz, attorney at law. Thanks for watching this video and thanks for visiting our website davidlentzlaw.com. If you've been served with a criminal warrant or with a traffic summons, I'm sorry, and I know that's extremely stressful, but we're here to help you to get the best result in your case possible given the facts and circumstances of it. Let me sort of run through briefly a little bit of the landscape here. All conversations that you and I would have would be in the strictest of confidence. I don't tell the police officers, I don't tell the judge. It's confidential. You need to know that. And I take that oath very, very seriously. Let me just say this. We always seek full acquittal, and you have a right to testify or not to testify in a case. We would discuss that further in our consultation. But we go thoroughly through the facts and circumstances of your case to see if there's what the best approach is to obtain full acquittal, meaning you have no penalties, no conviction, no record after the case. We make sure that the police have proper evidence, and what I mean by proper admissible evidence is that they didn't obtain evidence in violation of your Fifth Amendment rights to be free or not to convict yourself with incriminating statements and to be free from unreasonable searches and seizures under your Fourth Amendment rights. If we find that the police did not give you things like your Miranda warnings, which are your right to remain silent, they should have told you that anything you say can and will be used against you, and that you have a right to an attorney, and that if you cannot afford one, that one would be appointed for you. If they didn't tell you that at the appropriate time, then any statements you made to the police officer may not be admissible. Unfortunately, we find that a lot of people, I would say more than 50% of criminal defendants or people charged with traffic offenses, what they really did, and they didn't realize at the time, was they convicted themselves while they were trying to talk themselves out of the charge. So that Fifth Amendment issue is extremely important in most cases, and we thoroughly investigate whether or not we can keep any statements you made to the police out of evidence. Another thing is the right to be free from unreasonable searches and seizures. We make sure that if the police conducted a search and got some drugs, and found drugs or drug paraphernalia or weapons or whatever, that they got a warrant. And if they didn't get a warrant, we either object to that, or if there was some exception to the warrant requirements, we make sure that situation existed or didn't exist to see if we should file a motion to suppress on that ground. Let's talk about your right to a jury. You have a right to a jury in any case where you can potentially be given jail time. Now that's true in all Class 1 misdemeanors. Every Class 1 misdemeanor carries potential jail time, and in all felony cases. And I believe also in Class 2 misdemeanor cases, I believe also potentially carry jail time. But there are so few Class 2 misdemeanors, but that's beside the point. So anyway, ask about your right to a jury. In connection with that, it's important to discuss fees. I know you're very interested in that. The fees that I charge have a lot to do with whether or not a jury is going to be requested. So let's put juries aside for a second and just talk about non-jury cases where the client does not want a jury trial. In cases where a client does not want a jury trial, let's talk first about misdemeanor cases. In a simple misdemeanor case where there's only one or two charges and no prior record on the part of the defendant, nothing to complicate the case, not that many witnesses, you're talking down in the $500, $600, $700, $800 range. If I have to file a motion to suppress evidence because of a Fourth or Fifth Amendment violation by the police, that naturally costs a little bit more. If a client has a longer record, has a lot more witnesses, I'm still talking about non-jury cases now. The more complicated the case is, then in a misdemeanor case, you're getting up there closer to the $1,600, $1,700 range, maybe even in some cases $2,000. For like a really bad DUI case or a third offense DUI, it might go as high as $2,500. For felony cases. In felony cases, I've got to assume when I take a case that I'm going to have to appear 3 times. Once for preliminary hearing in general district court, once for trial in circuit court, and unfortunately I have to assume for sentencing just because in a fair number of cases there is a conviction. And also, even if we're lucky and get an acquittal and there's no sentencing, a lot of times that also meant that I appeared and showed up for a motion to suppress hearing, a 4th appearance, to keep evidence out under the exclusionary rules. So there's a lot of appearances. The bottom line is, in a non-jury felony case, fees range from about $1,200 to about $3,000. The number of witnesses has a large effect. The prior record of the defendant has a lot of effect. The number of charges has an effect. So that sort of gives you a range there. Now let's talk about jury cases. In jury cases, I've never actually had a jury trial where the trial itself, just the trial itself, forget preliminary hearing, not counting preliminary hearing and all that other stuff in trial preparation, where the trial itself lasted less than a day. That's because you got to select the jury and then you go through jury deliberations. Juries are cumbersome. I mean, just running the operation is a cumbersome operation. Jury trials take a lot of my time. So the bottom line is, it's almost inconceivable to try a jury case for less than $5,000. And what I find is that for most jury trials that I've had, the fees run between $8,000 and $12,000, $15,000 maybe. And the sky is potentially the limit. I mean, on jury cases, if you have a jury case that went on for a week or 2 weeks, for example, which is, I've never had one of those, frankly, thank goodness. They can you're $50,000, $60,000, but that's not the typical situation. So I've given you an idea, but like I said, for a jury trial, you're probably looking at $8,000 to $12,000. I guess you could get by with less than that, but that would have to be a fairly simple jury trial as jury trials go. Okay, let me just say this. No lawyer, myself included, or any other lawyer, can guarantee you results in a case. The reason for that is we don't know what the police officer is going to say. We don't know what the other witnesses are going to say. Sometimes witnesses will tell you one thing, and then you get up on the stand and they say something else. Okay, I need to interject here that while we do seek acquittal in all cases, sometimes it appears, even before going to court sometimes actually, that the evidence is going to be heavily against the client, and that we might be better served to engage in plea bargain discussions with the prosecution to try to get a more lenient sentence. Naturally, we try to get the best deal possible. That may mean, work release instead of jail. It may mean home incarceration instead of jail. It may be some sort of diversionary program, and naturally in DUI cases, where possible, which is
pretty often actually, we can get restricted driver's licenses in DUI cases along with the ASAP program. This goes part and parcel with the notion that the best we can ever do is give you a guesstimate, an educated guess as to what we think the outcome is going to be in a case, because litigation is inherently uncertain and results can never be guaranteed. I have over 35 years of experience. I used to be, many years ago, on the court-appointed list in Chesterfield, City of Richmond, and in Colonial Heights. Don't do court-appointed work anymore, but who knows? And you don't really know what anybody's going to say on the witness stand until they get up there and testify. Now, like I said, I repeat, you have a right not to testify, and your prior record is going to have a big effect on whether or not we're going to want you to get up on the witness stand. But you always have a right to testify if you want to testify. But you must do so truthfully if you get up and testify. So anyway, what we want to do is we want to work hard on your behalf to get you the best possible result in your case. Let me just say this: when you come to the initial consultation, it's always best to bring all your court papers, every piece of paper that the police or a court officer or anybody has given you, your warrant, your summons. Also, go to the state police website if you've been charged with a criminal offense and get a copy of your criminal record. That is really the only way I can give you a fair assessment of whether or not what you're likely, what I think a guesstimate, an educated guess of what your outcome is going to be, is to know what your prior record is. So if you can bring that to your initial consultation, that would be just excellent. If you just have a traffic case or a DUI, please go to DMV and get a copy of your DMV record. Okay, let's work together hard. You can call us to set up an appointment. The best way and the most convenient way, though, is to go onto my website, go to the Ask Leave message page, shoot me an email telling me when you want to set up an appointment. If you request a time some afternoon or on the weekends between 10 and 2, I almost always can accommodate you if you give me at least 48 hours notice. If I can't do it in the time you've asked for, I'll let you know right away and we'll reschedule. But in the mornings are bad because I'm usually in court, and that's the time when I'm almost never available to the phone. So like I said, thanks for visiting our site. If you want to learn a little bit more about me, David Lentz Law, you can go there and look. DavidLentzLaw.com. I have another website called ReasonandBalance.com. If you want to check out a few of the videos that I have there and some of the information, you're more than welcome to do that. That's ReasonandBalance.com. So I'm David Lentz. Thanks for visiting us, and good luck on your case.
Boop boop bop ba dum bum. Boop boop bop ba dum ba da dum da dum da da dum ba dum bum. Beep bop boop bop boop bop boop da ba dum bum. Beep bop boop bop beep beep boop bop ba dum bum.